Lawyers and Ethics, the Attorney-Client Privilege. Introduction. The attorney-client privilege is a legal principle that was invented with the advent of the law to prevent legal counsels from making known information that was given by their clients in confidence. The purpose of attorney-client privilege was originally designed to prevent pitting lawyers against their clients in the unlikely event that would have required them to be witnesses to their clients. It is one of the cardinal legal principles that has been around for a long time, and which is very hard to circumvent in a court of law. In the legal minefield that exists in today's modern world, the sanctity of the attorney-client privilege is always under constant scrutiny. Besides the major purpose of the attorney-client privilege, confidentiality, another important function of this principle is ensuring that clients benefit from high-quality legal advice, which can only be achieved when the attorney has complete details about a case. Elements of privileged information. According to the case scenario presented, the attorney has only two options: find a reason that would disqualify the information to be privileged and thereby find a basis for reporting the crime, or determine if the nature of communication qualifies for any of the several options that are legally accepted as exceptions to the attorney-client privilege doctrine. Three elements must be certified in attorney-client communication for it to be accepted as privileged information which cannot be made public. The person making known the facts must be a client, the person obtaining the facts must be a licensed attorney or a member of a bar, and the exchange of communication must be made to solicit legal advice from the attorney. Based on the case study, it seems that the communication between the attorney and client is indeed privileged given that all three elements have been certified. Circumstances that would disqualify the attorney-client privilege. Nevertheless, three known circumstances would disqualify communication from being certified as privileged despite the certification of the above conditions. These are the presence of unintended third parties who are not legal counsel at the time of communication, statements that indicate an intention of committing a crime prospectively, and waiver of the privilege by the client whether intentionally or unintentionally. Again, based on the case study, none of these options seems to apply, hence the attorney has no basis yet that would have disqualified the communication to be privileged and allow the reporting of the murder. Exceptions to the attorney-client privilege. Let us now assess the validity of the attorney-client privilege in the mentioned communication based on the legal exceptions that are generally allowed when it comes to privileged information. Several exceptions apply to privileged information between a client and an attorney. Therefore, we are going to discuss the exceptions that are only relevant to our case scenario. The attorney-client privilege does not apply when a third party is aware of the facts besides the client's attorney, regardless of whether such knowledge occurred before or after the communication with the client. This is one of the circumstances under which the law waives the principle of privileged communication. However, for the attorney to go down this road, it must be determined beyond doubt that the client confessed the same to a third party. One way of finding out about this is by asking the client if anybody else is aware of the facts of the murder. If the client says yes, the attorney can cite waiver of privilege by the client based on this fact alone and make known the information. Nevertheless, verification should be in order. This is because the law states that a waiver may occur even though the client does not intend to waive the privilege. Application of the legal concepts to the case scenario. Another factor that would exempt the attorney-client privilege would be the circumstances under which the communication of the information occurred. Legally, the law allows exceptions to the doctrine of privilege where the environment of such communications is deemed to have occurred openly. For instance, if the client made known to the attorney the facts of the murder in an interrogation room that had tape recorders. However, it must be shown that both clients were aware of this fact. The privilege of information does not as a matter of fact extend to physical evidence. The communication of confessing to murder and the whereabouts of the body is what is privileged in this case, but not the physical evidence of the body. The attorney is obligated by the law to present physical evidence to the police. If the attorney can separate the two, no breach of privilege of information would be determined to have occurred. Finally, breach of privileged information is allowed if the client at any time sues the attorney for malpractice or obtains a new trial based on the incompetency of the previous attorney, assuming this would happen.